I'm unmuted. I'm a little under the weather today, so I'm going to do my best. Um, I got a sore throat and upset stomach, but I'm here, and then I'm going to go lay on my couch and take a nap when this is done.
Okay. Oh, I'm so sorry. Um, well, thank you for braving your illness. Um, I'm going to ask you, let's see. I'm actually going to reclaim real fast. Okay. So, everyone, welcome to our Community Over Chaos series for August and our grassroots fundraising. We are the well, first off, I'm Hope Williams, just here for support, tech support, but I'm the Director of Legislative Advocacy for the Sustainable Economies Law Center, and I help run our legal cafes where we assist 500 people in orgs per year with free legal advice. We'll be dropping different things into the chat, including the evaluation form and the handouts. God willing, if there aren't too many tech difficulties today, we'll also make sure you get the materials afterwards via email. The Sustainable Economies Law Center is 15 years old, and I always like to do my own little spiel, which is Sustainable Economies Law Center is trying to create alternative social constructs outside of the one we currently operate in, and we move through this world with love and nurturance and try to make the legal world as radically accessible as humanly possible. So happy now to be here today to let Jay introduce himself. Go ahead, Jay. Oh, and we thank you to our sponsors.
Yeah, these are our sponsors. Hi, everyone. Yeah, my name is Jay Cumberland. I'm a staff attorney at the Sustainable Economies Law Center. I do work in our labor practice and also in our housing practice. And I think this presentation blends a little of those things together and lets us talk about the way that housing shapes the labor that goes on that's mostly unwaged, that happens within homes. So this is the presentation on ending zoning's focus on the family. And I believe I could just dive right in, Hope, right? We're ready to go?
We're ready to go.
Okay. Well, thank you for coming today. I'm just going to move through a few sections of this presentation. Like I said, I'm gonna have to pause for some water because I have a sore throat and don't want to lose my voice. But this is where we are headed today. Um, First, I'm gonna give you an introduction to the concept of what is a private nuclear family. What does that mean? What's the history of that term? Second, why and how has zoning focused on the private nuclear family so much? I'm gonna give kind of an eras tour. Of the different eras of zoning's focus and how it's mutated and shifted over time, especially in California. And the Law Center is actually working on a proposal that we're hoping to find a legislator to move forward in California to try to end zoning's focus on the family and open up a new era for zoning that is focused on housing for all types of relationships, for all type of people, no matter how they want to live together or what amenities they want to have or not have. And I want to explain the consequences of our proposal for. I think this is a proposal that can really support California's efforts to address its housing crisis. So I want to explain that. And then I want to explain how, in a way, radical this proposal is, not in like a radical revolutionary sense, but radical in like it gets to the heart of zoning law and requires a lot of changes to planning codes and things like that that you might not expect because it cuts so deep into the way the system is structured. All right, that's where we're headed. So I'm going to move into our first section on the private nuclear family. So what does that mean? It really has two concepts that are joined together to create one overall concept, I guess. First is, what does nuclear mean? Nuclear is really like a derivation of the term nucleus. The nucleus is like the core of an atom, and the other things are on the periphery, like the electrons and stuff like that. So the nuclear family is about the core members of a family, meaning like traditionally a husband and wife and some kids. It contrasts with the extended family, which are these traditional sort of extended kinship networks, like your aunts and uncles, your grandparents, and other people that you might live with, whether you're related to them or not. This term really came into vogue in the 1920s or 1940s to try to define some new cultural trends with respect to family formation and to distinguish this concept of family and this image of family from other sort of historical forms. And then there's the private component of the nuclear family. The private component is about these core members of the family living separately from other families and even separately from non-core family members, living by themselves as sort of a small core family unit. And when they're living by themselves, what they're doing privately is managing the labor that takes place within a household, which is the labor of raising children, the labor of cooking and doing laundry and cleaning and like providing emotional support and just interpersonal care generally to each other. That is like compressed and condensed within the home and privatized in a way. It's not happening in public. It's not happening primarily with other people, but primarily with these people in this family unit. And it's also tied into the construction of the home, this image of the home as like an apolitical or non-public space, or a place of refuge, a place of solace, a place where we escape from society. Historically, it's connected to the separation of places where we work and places where we live, and the construction of the home as a feminine space, separated from the political space of like men in factories and stuff like that. So that's the concept. How did we get here? Like I was saying, this came into vogue, it came into terminology in the 1920s, 1940s, because of some social changes. Principally, it was related to a rise in immigration into the United States in this time period. There's a great book that talks about this called Stranger Intimacy, which says that because of rising anti-immigrant sentiment related to the ways that immigrants formed families, their immigrant sexualities, immigrant relationships, there was an effort to define the modern sort of American version of the family against the immigrant version of the family for Mexican immigrants in California, Japanese and Chinese immigrants, and then after the end of World War I, European immigrants to California. The agency in California that took charge of this was an agency called the California Commission of Immigration and Housing. This is their pamphlet on the right. They waged basically this campaign to Americanize immigrants. And they were focused both on immigration and housing. That was their dual mission. And so they would do things like go to immigrant families and tell them that the way that they were living was improper. They would talk to immigrant mothers and say that you shouldn't be cooking communally. You shouldn't be living with other families. This is improper. It's really only proper to cook and live as a nuclear family unit, set apart from other families. So that was the origin of that term, the nuclear family, and the origin of the push for that kind of living, that private living, that nuclear family living in America. And then it really took a turn after World War II in American history. This is again right after a war. Women were in the workforce, men returned home from war en masse, and there were things like the GI Bill, that encouraged homeownership, that encouraged the creation of suburbia, a suburbia of single family homes. And there began to be this more sort of American dream associated with single family homeownership, like you can see on the left with this General Electric pamphlet and this kind of dreaming and scheming of living in a home as a nuclear family unit. This was enabled in part because of rises in sort of production and rises in the labor movement, ironically, in the United States that enabled the creation of this family form of a male breadwinner and female housewife family, where a man could make enough money in a unionized labor job to be the sole breadwinner. And a woman who was pushed out of the workforce after World War II could live in the home and take care of the home as a housewife. So just as there was advertisements about creating a family in this home, this single family home that you see on the left, there was all this sort of propaganda focused on women's role in the home and their housekeeping. At the same time, there were political changes to reinforce this new social trend. So for example, FDR, the president, made a State of the Union speech on the second bill, called the Second Bill of Rights in 1944 at the end of World War II, and talked about the right, not of everyone to a decent home, but the right particularly of every family to a decent home. At the same time, or shortly after, the Universal Declaration of Human Rights at the international level began to say that the family was the natural and fundamental group unit of society. This was the normalized unit. This was the unit that was going to be supported. And so this new family form and this new respectable portion of the working class kind of constituted itself in opposition of other kinds of groups in society that weren't able to attain this family form, that weren't able to take a woman out of the workforce and put her in the home, to the criminalized, to the queer, to all these other types of family groups. So that's sort of the quick social history of the private nuclear family that I'm going to give. And now I'm going to move on to the second section, which is zoning has been peculiarly focused on this private family form, this private nuclear family, for a long time. And it's gone through a lot of different historical shifts over time, too. So there was a time in America, a time in the world before zoning law. Primarily, that was a time before the 1920s or the 1910s when zoning law began to take off in America and in California. And there's a great book explaining what housing was like, especially in America's urban areas before that time. It's called Living Downtown by the late Paul Groth, I think from Berkeley, so nearby where I am in California. It said that in a conservative estimate, up to 1/2 of all urban Americans lived in some kind of like communal housing at this period of time. They were either living like renting someone's spare room in their house and that person was cooking for them and living in like a boarding house, or they were living in what was called a residential hotel where they rented a bedroom and had access to sort of this shared living space, this shared parlor, meals that were cooked for them in the hotel cafeteria, laundry service that was provided to them, shared bathrooms, places to like dance and gamble and live life in a more public setting is the way that many people lived in urban areas at this time. A writer has described this housing contrasted to what we have now as much more flexible and fluid and communal, which means that there was lots of different ways that you could live, and there wasn't this one sort of one size fits all way that we typically encounter now of living in a dwelling unit in a place with bedrooms connected to a private kitchen with private bathrooms behind locked doors. And this flexible, fluid, and communal housing began to sort of be attacked, I guess, by zoning law in the early 20th century. The California Commission of Immigration and Housing, that organization I mentioned just a few minutes ago, that waged a campaign to Americanize immigrants, also was the organization that created zoning law and was tasked with enforcing it in California. They created the 3 original California zoning laws in 1917. One was the Dwelling House Act for small apartment buildings and single-family homes. One was the Tenement House Act for larger apartment buildings. And one was the Hotel and Lodging House Act for these types of communal facilities that I was talking about earlier. So there were core features of this original Dwelling House Act. One is that it did define a dwelling house as for a family, and said a family was one person living alone or a group of people living together in an apartment. And then it had this clause that took me a little while to understand, which says a family was this group of people, whether related to each other by birth or not. So whether related to each other by birth or not means, after I've researched and figured out what that means, because it was confusing, it means related by birth. So like a husband and a kid, a wife and a kid, a grandparent and a child, or related by law, which means related by marriage or related by adoption or something like that. So it means related by blood or law. That's what a family was according to this original definition. And a family was entitled to live in an apartment, which is a room or suite of rooms that's either occupied or intended or designed to be occupied by one family. And what did these look like when they were multifamily units? This C clause is really illuminating in terms of what the intentions were for how these nuclear families were supposed to live. It says that anytime you have 4 basically apartment units in a dwelling house, you had to make sure that the families could live independently of each other, so that there was a residence for each separate family. And they went so far as to say that each section had to have an entirely independent and separate entrance. So, and there could be no room, no hallway, no bathroom, no toilet, no kitchen used in common by more than one family. And this makes sense when you really think about what the term apartment means etymologically. It literally means to set apart. They were trying to create a classification in zoning law for housing where families lived apart from one another, where they lived completely separated in these private units. They were creating housing for the private nuclear family. The federal government also got involved in this when they saw what California was doing and they wanted other states to follow suit. So at this time, Secretary Herbert Hoover, later President Herbert Hoover, took charge of creating an advisory committee on zoning in the Department of Commerce, and led to the creation of this standard state zoning enabling act. The first time the federal government got involved and the last time the federal government got involved in zoning law. There's a great book called The Color of Law by Richard Rothstein, which says that this campaign by Hoover, this creation of this act, was essentially a propaganda campaign targeted at middle-class white folks to convince them to move out of apartment buildings and to move into single-family homes. So this is how the state of California got involved. This is how the federal government got involved to set this whole thing in motion of zoning laws focused on the nuclear family. But there's this interesting situation that happened, which is that courts didn't really care for a long time. These zoning laws came about in the 1910s, 1920s, but from 1920 to 1950s, the courts ignored the legislative intent of these zoning laws. The article that provides the best history of this that I found is this article by Kate Redburn called Zoned Out, which is about how zoning law undermines family law's functional term. It says that courts routinely ruled that functional families, which means families that are not related to each other by blood or law, were routinely allowed by courts to live together. Courts allowed gay couples who didn't have the right to marry to live together. They allowed religious adherents like convents, monasteries, ashrams to live together. They allowed sororities to live together in dwelling units. They didn't care. And they did this by basically creatively interpreting legislation in most cases. By the time that these cases were coming around, most states no longer used this whether related by birth or not clause. And instead, they were saying that a family means people living together as a single housekeeping unit. And so in order to allow these unrelated families to live together, despite what the legislative intent was, courts took two approaches. First, they either said that the dictionary definition of family didn't match or wasn't confined to people related by blood or law. At that time, because the concept of the private nuclear family was still sort of arising, family had a much more expansive definition. And so they said this term family here can't mean just that. Even though it was clear from context, like that's what it was intended to mean, court said that you didn't define it well enough, so we're not going to let you limit it to that. Other courts took a different approach. And what they said was that this term, single housekeeping unit, modifies and explains what the term family is supposed to mean. So they didn't look to the dictionary definition of family, they looked to the actual text itself and used this concept to explain what family meant. They said that single housekeeping unit modified the term family, and since it wasn't explicitly about relationship by blood or law, family couldn't be limited to a nuclear family. It was about how people lived together, the types of relationship they had, whether they cohered as sort of a single unit. But I think it's worth asking, is that what single housekeeping unit actually means? Or is this just courts getting really creative to accomplish the goals that they had, despite the legislative intent and what these terms actually meant? I think for me, the concept of the private nuclear family and applying this to zoning law has helped me understand what was actually meant by these terms and how courts were being so creative in analyzing them. For me, the family, it's clear from the legislative history, from the social context, meant a nuclear family, or at least people that were related by blood or law, including extended family at that time. And a single housekeeping unit was about the private element of the family. was what it was intended to be about. That's because housekeeping unit wasn't a term that was about how people lived together or what types of relationships that they had. It was about the types of facilities that were included in rooms. The term housekeeping unit is a term from building codes, which literally means a unit that includes housekeeping facilities, which are things like kitchens that you use to keep house, that a housewife would use, or bathrooms. You can still see these definitions as sort of legacy definitions in places like the San Francisco Building Code, which defines a housekeeping room or a housekeeping unit as a unit or room containing cooking facilities. That was permitted before like 1969 when this definition was struck and this category was removed. So what a single housekeeping unit meant was that there was only one kitchen. It meant that there weren't two kitchens. There wasn't a two-story building with an aunt and uncle living downstairs who were using one kitchen and sort of living their own separate lives, and a married couple with kids upstairs living their own kind of separate lives too. It meant that they all had to use the same sort of core housekeeping facilities, or the core kitchen, really, is what it meant. So when courts began to interpret it as being about the relationships that people had, this was somewhat related to the intention, but not really entirely accurate at all. And it's important to understand what these things actually meant and the difference between the legislative intent and the creative jurisprudence by courts to get the history right and to understand how to intervene and modify these ordinances. You can see San Francisco getting this history wrong in real time right now with an ordinance that Supervisor Bilal Mahmoud is proposing to change the definitions of family and dwelling unit in the planning code. This is the history that it includes. It says, before 1978, the planning code didn't distinguish between related and unrelated people for the purposes of defining a family. It says, for example, the 1957 planning code defined a family as one or more persons occupying the premises as a single and separate housekeeping unit. So this history on the left is true in kind of a trivial sense. It's true that the definition of family before 1978 was a family is one or more persons occupying the premises as a single and separate housekeeping unit. And it's true that that clause doesn't say anything about whether people are related or unrelated. But it's also clear from that time that as early as 1917, California had a definition of family that San Francisco adopted and used that did define family. They adopted the Dwelling House Act from 1917. That was the act that applied to the whole state of California. And it's clear from the time that they thought the term family was self-evident in speaking to people that are related by blood or law. And it's also, I think this is actually also a helpful citation to see what the meaning of single housekeeping unit was in historical context, because this doesn't just say single housekeeping unit, this says single and separate housekeeping unit, which helps to explain what single housekeeping unit actually meant in legislative terms, because it's about this separation that I talked about in this paragraph, about making sure that families lived completely separate lives and didn't share any room, hallway, bathroom, toilet, kitchen, anything like that. Like that's what that term actually meant. And so it was about people being separate and keeping related people apart from each other. So they get that history wrong. But this turning point in 1957 is important to understand, because this is when things changed significantly after World War II. After World War II, like I was talking about, there was a push for the creation of the male breadwinner, female housewife family form, for the creation of suburbia, and for the defense of that family form that was being created. You can see this as sort of a critical document. For me, this is like a core religious text of understanding what was going on at the time. It's a text from the time that San Francisco ordinance points out, 1957, by the American Society of Planning Officials. It's their information report on rooming houses. The purpose of this report is to enable jurisdictions to write better legislation that prevents courts from using the types of creative interpretation that they have been doing in order to undermine the legislative intent of cities, to exclude rooming houses, to exclude group housing, to exclude unrelated people from single family zones and zones that allow dwelling houses that are slightly larger. That's the purpose, is to help people write better legislation. So this article summarizes all of the court cases, all of the interpretation that courts have been doing, and proposes a model standard for better legislation that will prevent courts from allowing rooming houses to exist next to single family homes and dwelling houses. So what they propose is to do what San Francisco said hadn't been done before 1957, to write into the definition of family relationship requirements. So their model definition of family is that it is a group related by blood or law and living together as a single housekeeping unit, or it's no more than 5 unrelated people living together as a single housekeeping unit. So this is why it's true that no one before 1957 was using this related by blood or law requirement at the time. And after 1957, they were, because the American Society of Planning Officials says this is what you should do to achieve your goal of ensuring that there are districts solely of private nuclear families living together, not next to any other types of groups. They also continued to kind of misunderstand what a single housekeeping unit meant, but they ensured the effect was, I guess, carried through, I guess is the best way to say that. They said that you should redefine the term dwelling unit too, to ensure that it had a private kitchen. And this would also prevent rooming houses from being next to dwelling houses, because group housing doesn't have private kitchens as one of the core components of it. So after the 1950s, the 1940s, courts' hands are tied by better written legislation. They're not able to allow functional families to live next to each other like they used to be allowed to, because they don't really have the wiggle room to creatively interpret. And even when their hands aren't tied by better written legislation, they still rule against functional families more, because they're following changing social trends. They're following trends towards the creation and the elevation of this private nuclear family in the male breadwinner, female housewife family form. They're following sort of prejudice against communal living created by sort of the hippie movement and stuff like that, that families, these new families, perceived as a threat to their way of living and their ideal family form. They're following the deinstitutionalization of mental health in America, which led a lot of mentally ill people into these previously flexible, fluid, and communal living spaces and made them sort of worse places to live. And they're wanting to prevent those. They're wanting to follow the social trends of prejudice against those types of arrangements that was rising at this time, even more than in the 1920s. So then, this is not the state of affairs in California today. But California did, most jurisdictions in California, like San Francisco, like Santa Barbara, adopted this American Society of Planning Officials definition of family. So the case that overturned that definition in California was Santa Barbara v. Adamson. Santa Barbara at that time defined a family as people related by blood or marriage that lived as a single housekeeping unit, or no more than 5 unrelated people living as a single housekeeping unit. And this case said that that is not allowed. You can't artificially limit the number of unrelated people living together while you're not at all limiting the number of related people that are living together, is the ruling of this case. It says that you have to allow an unlimited number of unrelated people to live in a dwelling unit, so long as they function as a single housekeeping unit. So this case continues in the lineage of interpreting the single housekeeping unit as about the actual relationships that the people have. It says a single housekeeping unit is a group of people that share emotional and psychological ties and share expenses and are relatively permanent and control their own membership. That's not at all what it actually meant in historical context, but that's what it's come to mean in the law as a definition of how people live together. And importantly, to claim and to win the right to be qualified as a single housekeeping unit as a group of unrelated people, you have to still argue, like the Adamson litigants did, that they share family values, that they consider themselves to be a family, that there's nothing different between them and a nuclear family. The consequence of this ruling in California is that there is a reduced focus on the nuclear element of family, on the related element of family. But at the same time, there's an increased focus on the private element of family. Family, according to Adamson, is essentially redefined as a group that lives privately, as a group that has their own kitchen, as a group that has their own bathroom behind locked doors, and that is sort of living in their own lives. It's literally a case that is established on the grounds of it would be an invasion of privacy. It would be against the right of privacy in the California Constitution to rule otherwise. So this is a case decided overall on the right to privacy, on the right to separate from society and not have anyone sort of peer into the way that you're living. There's also text at this time, social changes. You see the World Health Organization at this time in 1989 write a report on the health principles of housing. And what it says is that adequate housing or habitable housing isn't just about having a roof over your head that keeps rain from getting in. It isn't just about protection from the elements and rodents and things like that, but it's also about psychological health. And it says that a core component of psychological health and mental health is having a private place of your own that is a refuge from society. So they begin to tie and sort of double down on this privacy element of housing being essential for health, for habitability, as like a moral analog to sanitation requirements, essentially. And that continues to this day. In movements recently, like ACE, or the Alliance of Californians for Community Empowerment, their report on arguing for a right to housing in California, they echo that World Health Organization report from 1989 and say that habitability doesn't just mean physical health and safety, but also is about fulfillment of people's psychological needs, including having a private place of their own for themselves and their family. I think it's time that we recognize that doesn't create health at all. There's recognition that we live in times where we have an epidemic of loneliness and isolation. And if the type of housing that is prioritized is housing that requires us to live completely separate lives in our little dwelling units, walled off from our neighbors, then I don't think that this promotes health. And I don't think that this pursuit of this family form is fulfilling our psychological needs at all. I think it's actually resulting in a lot of social detriment. And so I think that as we argue for a right to housing, we have to recognize this history of why we're arguing for a certain type of housing. And we need to interrogate this history and understand what its purpose was and what it was arguing for in order to change it. And so that's what we want to do at the Law Center. We've been working to draft an ordinance called the Housing Choice for All Act that would end zoning's focus on the family in California. And we think we need to do that now in California. Just as the federal government got involved in zoning law 100 years ago, they're poised to get involved in zoning law next year, potentially. The Road to Housing Act of 2025 has passed the Senate, or has passed the House. I think it's going to the Senate. I don't think it's passed yet, but as this article says, the almost 100-year wait from 1924 to today is almost over. This act would direct the U.S. Department of Housing and Urban Development to write model state zoning laws for states to adopt to encourage housing production. And I don't think that California can stand to have the federal government, with its particular gender politics and its particular family politics that are very similar in a way, with its particular sort of Americanization campaign and anti-immigrant focus, to be the one writing model state zoning laws. I think that California should get in front and begin to set a standard for doing zoning in a different way. It's been a century, and it's time for us to change. And what we would propose to do is to remove these distinctions that have enabled prejudice against non-family groups and against group housing units. So we would remove these definitions that have existed for a century, from 1917 to 2025, because it's clear from the social context from what the movements themselves have said, and even from how they're used today, that the only purpose of these ordinances has been to exclude certain types of people that are not living as a family and not living privately. And that's not a legitimate purpose that we should allow our zoning laws to have. We would remove these distinctions by banning relationship requirements for certain units. We would ban any type of relationship requirements, not only blood and law requirements, but also single housekeeping unit requirements and any other requirements that apply to one type of unit and not to another type of unit. San Francisco, for example, right now, in that ordinance that I talked about that Supervisor Bilal Mahmood is proposing a partially good thing that would reduce the single housekeeping unit standard in California and make it a less stringent standard. But we think there should be no standard at all that requires a higher standard for dwelling units than for group housing units, and suggest that this one type of unit is better because you have to jump over more hoops in order to live in it than this other unit. This would remove the privilege that related people have, and the remaining distinctions between group housing and dwelling units would be about whether they're private or communal. And we want to ban those types of distinctions too, because we think those distinctions have no place in our housing law. So we would suggest banning the private kitchen requirement for dwelling units so that they're no longer able to be required to have this, to be a single housekeeping unit, either in terms of the facilities that they have or the relationships that people have. Now, cities have gotten creative in California in recent time. In 2005, the zoning administrator of San Francisco ruled that group housing units or rooming units could have what are called limited private kitchens, which are kind of like kitchenettes, like tiny kitchens. So what that meant is that it was much harder to distinguish between group housing units and dwelling units because they both could have kitchens. So Supervisor Peskin in San Francisco wrote an ordinance in 2022 that banned limited private kitchens in group housing because it blurred, in his mind, the distinction between group housing and dwelling units and made it more possible to create group housing that wasn't wanted. So we don't want people to be able to ban limited private kitchens. That ordinance by Peskin also required communal kitchens in group housing unless it was completely affordable housing. We don't want there to be any kitchen requirements. You can make SROs, you can make residential hotels that don't have kitchens. You can have communal kitchens and limited private kitchens. You can have a private kitchen for every unit. We want kitchen anarchy. You can do whatever kind of kitchen thing you want, but California shouldn't be legislating what kinds of kitchens you should have and creating higher standards for one type of unit than for another. This would remove the privilege by zoning law that has been granted to people living private lives and allow there to be a choice between whether you want to have communal facilities or whether you want to have private facilities. We're not trying to legislate one or the other, but we're trying to remove this century of prejudice that has led us to have this one size fits all built environment. There's a lot more that would go along with this, but those are the core components of it. We would also want to allow multiple primary residential facilities per lot to support groups that are building like intentional communities or wanting to have more like build cottage courts or bungalow courts or whatever. That's not allowed in a lot of places, and we think that should be allowed. We would ban different bathroom standards. Currently, the California Plumbing Code, which is this seemingly neutral thing, it's just about plumbing, echoes these moral trends and requires a private bathroom for dwelling units, but only requires a minimum of 8 toilets. No, it's 8 showers and 12 toilets per every 10 rooming house units or something like that. Those standards should be neutral. There should be a universal standard that applies to all types of housing, not one standard that creates private housing that is privileged versus another type. We'd also want to require that group housing be allowed for all types of groups. Right now, there's cities in California like Fresno that actually don't have any relationship requirement for living in dwelling units. Their only requirement is that it be private, that it have a private kitchen. But on the other hand, they only allow group housing for special groups that they deem to need communal facilities like the elderly or the disabled or people with substance abuse disorders or things like that. We shouldn't create this prejudice against communal housing and say that only sort of the down and out in society need this type of housing. I live in a private nuclear family with a child, and I would love to live in communal housing so that I don't have to cook all my meals all the time by myself, you know? I think this is something that everybody should have the choice of whether they want to live in it or not. We would also require that supportive housing be allowed for all groups. Basically, supportive housing is housing where you have communal facilities that maybe there's a service provider, maybe there's a chef or a company that cooks the meals for you, or that does your laundry or something like that. This is currently in most places only allowed, similarly as Fresno allows group housing for special needs groups, the elderly, the disabled, people with substance abuse disorders, things like that. We think that that should be allowed for all types of people, just as it was in the early 20th century, when lots of people lived in hotels that had cafeterias where meals were cooked for them, where their laundry was done. It shouldn't just be a choice between handling things communally and privately and without money, or handling things. There should be a choice between whether you do things unpaid or whether you pay for these services, which is what people are doing now, but just all privately. What would the consequences of this be if this was actually passed? First, we think that this will visibilize group housing and allow California to build a lot of different types of things that they're not currently allowing to build. Right now, according to the regional housing needs allocation in California, most types of group housing are not counted as units that are contributing towards cities meeting their housing goals. So if you build a group housing project, it doesn't knock off 10 units from the housing goals that cities are trying to meet and have to meet by state standards. Now there's efforts underway, including by the Housing and Community Development Department, to count more group housing units in their laws, but they're still not counting all of them. And they should be counting all of them already, but they're not. You can read this Gimby Law Journal article that talks about how dorms, SROs, and other types of housing under the legislation that authorizes RHNA, these already do count, but California is being sort of deliberately ignorant about these counting and not wanting to count them. And this also is part of a centuries-long campaign of what Paul Groff in his book Living Downtown calls deliberate ignorance as a professional strategy. This section of the book talks about how planners and housing officials and city staff have for a long time just intentionally not counted group housing as real housing that meets people's needs. So when they're counting how many units they need, when they're counting how many people live where, they just have not counted group housing at all, in the hope that if they don't look at it, it will go away. And it needs to be counted, and it needs to count literally towards meeting housing needs. And we think that this will enable a better response to California's housing crisis. Right now, some of the crisis is just due to changing family forms. We have homes, a lot of older homes and apartments that are built for the families of times past that had 3.8 people per house. Now we're on track to only have 2 people per family. But there's still prejudice against families renting out their guest rooms or sharing the rooms or operating boarding houses or things like that. And by removing that prejudice and by removing the relationship requirements that might make filling those spare rooms difficult, we think it will allow the existing housing stock that we have to be better utilized. It'll also allow changes like, I think a good example of this is the city of Oakland. The city of Oakland has the typical dwelling unit requirement, which is that you have 1 kitchen, but you can get a conditional use permit to have a second kitchen in your house, only on the condition that it doesn't somehow create 2 families living in a space versus 1 family living in a space, which is really hard to wrap your mind around. But what this would also allow in houses with 2 levels or something like that is to put a kitchen downstairs so that a family can live as like a separate unit in your house without having to convert that house to a duplex or something like that, which is much more expensive. It would also bring back single people housing, these tiny homes, single room occupancy, micro units. These would all be allowed because states would no longer and cities would no longer be able to discriminate against housing that doesn't include private kitchens or that have communal facilities. these types of sort of naturally more affordable housing that are affordable oftentimes even without subsidy are looked down upon. And people should be allowed to choose them if that is the housing that's affordable to them and that meets their needs. It would also remove barriers to office to residential conversions in California. There's a lot of great work that's been done by Pew on how co-living could unlock office to residential conversions. California, like a lot of places after the pandemic, has a lot of vacant office space that cities are putting a lot of lip service towards converting to housing. But the housing that this is best suited for is group housing, which cities don't generally like. It's best suited for that because the plumbing in these buildings generally runs to one kitchen that's used to serve the people working there, or central bathrooms. And it would be really expensive to put private kitchens in all these and create private kitchens for a bunch of units and run new plumbing up these skyscrapers and stuff like that. It's much easier. It's 35% cheaper just to have a central kitchen where the kitchen already is, and to have shared bathrooms, and to have people rent bedrooms and living space. And beyond how this contributes to meeting housing supply, it is fairly radical in the sense that these changes they sort of get to the bedrock of what our housing system is built upon in California and in the United States, because everything assumes that the standard is the dwelling unit. We've already talked about how RHNA, the Regional Housing Needs Assessment, assumes the dwelling unit is the standard, but also our residential facility classifications, which means things like single family dwelling unit, 2 to 4 family dwelling unit, multi-family dwelling unit. Those have to change. Not only can you not classify things based on whether they're for a single family or for multiple families, so you have to strike family, but you have to strike dwelling unit. You can't define those based on being dwelling units or not dwelling units. You have to come up with a different way to define what is allowed in different zones, not based on how many rooms that happen to be attached to a private kitchen. Cities will have to come up with ways to define whether that's based on the floor area ratio or building envelope or something like that, some neutral standard that doesn't look into how people live for what's allowed to be built. Similarly with accessory dwelling units wouldn't be a classification anymore. So it would just be an accessory unit, which means there's not really any difference between adding a bedroom onto a house or creating something that might only have a bedroom in the back of your yard that's detached. The only difference is whether it's attached or detached. So we're gonna have to redefine what an accessory dwelling unit is. And why there should be a ministerial approval for certain accessory dwelling units and not for room additions or things like that. We're going to have to intervene in those laws and change the way that the definitions are structured. I feel like I just want to stop for questions. There's all types of things that are built on this unit standard that would have to be changed, and to create more neutral standards that don't discriminate between dwelling units and group housing units. What I hope to be able to do is to write a model planning code to show what all these changes would be, and to suggest some choices for cities to adopt, some codes for cities to adopt if this ordinance goes through. Because I think having an understanding in concrete terms of what this would look like is important to explain the impact. All right. You can sign up to stay tuned if you look up the Housing Choice for All Act on the Sustainable Economies Law Center's page. You can give us feedback. You can sign on to support. You can add your email to just get updates as we move forward. We'd love to be in communication, hear your feedback. This is sort of our second time workshopping this. And we'd love to hear from as many people as we can to help make this better. So thank you, for sitting through me talking for a long time. I know there's a lot in the chat that people may want to talk about. So I will stop sharing and
Thank you.
take questions. Yeah.
Yeah, Jay, good job. We have someone who has their hand raised. It's Sarah. So I'm gonna ask Sarah to go off mute. Actually, I think I can do that myself, but go ahead, Sarah.
Yeah, I basically work in terms of preserving sort of grassroots sort of naturally occurring affordable housing. And one of our sites, actually, we're basically dealing with this have dealt with this family issue in terms of using the San Francisco unit legalization ordinance to, convert something. And, I'm very familiar with their standards on group housing. But, one of the things I guess like my question or the thing I wanted to ask is if you're familiar with AB 507 that's going through the adaptive reuse bill and sort of what your thoughts are on that.
I am not familiar with it. Hope, are you familiar with it?
Anytime I think of adaptive reuse, I think of what major corporations buying up office buildings and then turning them into residential properties that aren't subject to any rental protections. It's
Right,
my only light opinion about what I think.
right.
Is that Matt Haney? Assembly member Matt Haney?
Yeah, yeah.
Yeah, that's my thought, Sarah. And thanks for bringing your questions forward. Did you have any other questions or comments?
I guess it was just, the idea that, um, this this idea of sort of removing some of these limitations and restrictions, could sort of help create, turn some of these office buildings that you were talking about, into that. And like, well, one of the provisions in the adaptive reuse bill is that they're basically giving, sort of more perks or waivers for affordable units.
Yeah. Well, thank you for raising that, Sarah. Definitely want everyone to continue to give their feedback and expertise and insight. And I happen to know Sarah, and I know that she has a lot of expertise and insight. So
Yeah.
we have about
Yeah.
5 minutes left. Jay, did you want to say anything else? Okay. All right.
I just had one more thing. I'm sorry. Could I say one?
Yes, please.
Go ahead, Sarah. If you want to unmute.
Yeah. A lot of, it's like a lot of these sort of specifics that you're talking about in terms of, sort of the planning code in terms of the kitchens and the bathrooms. I think like the one thing that might need to be addressed in this would be issues around egress and escape and rescue and things like that. Because there's the issue, there's this whole issue around intervening space. And the idea is like, if it is a group housing, it's like this issue around privacy and, who controls the space. So I feel like that, if that is in it, then I'd be interested to see how that's addressed. And if it isn't, I feel like it was something that would be need to be addressed.
Yeah, Jay's shaking his head, nodding his head. Absolutely. Excellent. Well, I look forward to having more discussions around this presentation. If everyone want to raise their hands and clapping for Jay for doing so well. I believe this is our, thanks everyone. I believe this is our last MCLE for our grassroots fundraising campaign for the month of August, but always here for folks. Please let us know if you need anything in the future, and we will be here for you. But I think that's all, folks. Sound good? All right.